I'm just really going to focus very, very quickly on the main components of legislation that we are going to come across this year in 2020, and also other matters that we should be mindful of. I do apologise in advance for those of you that were at the last meeting, Council Forum, back in August, end of August in Forest Fields, because there'll probably be a bit of duplication in terms of what I'm going to say this evening. But I'm going to start off with what I consider as being the most important piece of legislation that's hit our sector since the 2004 Act, and this is the extension of the Homes Fitness for Human Habitation Act. This originally came out in March 2019 for all new tenancies, but it will apply to every tenancy as from the 1st of March of this year. Don't worry about making too many notes, because this presentation will be available for those that want it. I can email it to anyone as from tomorrow. So essentially what this legislation is saying is that landlords need to ensure that their properties are free from any sort of hazards at the commencement of a tenancy in particular. And the sort of hazards that we're talking about are the hazards that come under Part 1 of the 2004 Housing Act, the HHSRS, which is the Housing Health and Safety Rating System. 29 hazards. If you're not familiar with those hazards, you're not accredited with Dash or Unipol, I would really strongly recommend that you go onto Google and look them up. So you've got to ensure that when you rent a property, that none of those hazards exist within the property. And if they do, please get them sorted out straight away, because essentially, if there are hazards in the property, what it essentially means is that the tenant, all they need to do, if they're familiar with this legislation, I know some local authorities are informing tenants about this legislation, all the tenants need to do is go to their computer, download a court form, the N1, take a photograph, so if it's some damp in the kitchen or bathroom, mould, etc., or a loose handrail, they need to take a photograph of that, fill in the court form, staple the photograph to the court form, pay the court fee, send it off to the local court. The first you're going to know about this is when the notice from the court arrives on your doormat asking you to defend this challenge, okay? And so essentially it's forcing us as landlords to conduct proper inventories, inspections, and to confront any notification from a tenant in terms of a hazard, for us to promptly deal with that in a very efficient manner. We need to keep records under this legislation, and in terms of the compensation, we don't know what the compensation will be. Okay, it's still not determined, so it will really be up to the judge in question how he deems the seriousness of the particular hazard. And as I say, there are 29 of them under HHSRS. Landlords will only be liable from knowledge during the tenancy. So if the tenant during the tenancy discovers a hazard, unless that tenant tells you about that hazard, you will not be implicated in terms of this legislation. The legislation also applies to common areas in HMOs and blocks of flats. So the sort of thing the courts will be looking at in the unfortunate circumstances you are hauled into court, they'll be looking at the building, they'll be seeing whether it's been neglected, whether it's in good or bad condition, they'll be looking to see if the building's unstable, has an unsafe layout, whether it has serious damp or mold issues. They'll be looking at the natural light or ventilation, etc., etc., etc. Okay, so really familiarise yourself with this piece of legislation. If you take nothing else away from my presentation this evening, please look at that in a bit more detail. I've included something on the How to Rent guide. There's been 8 of these since the 1st of October 2015, when they first appeared under the Deregulation Act of October the 1st, 2015. Now, this particular pamphlet or guide is essentially telling tenants what their expectations should be from a responsible landlord, what they should be getting in terms of a proper written tenancy agreement and smoke detectors, etc., etc. And the reason I put this in my presentation is the 6th copy of this guide came out on the 31st of May of last year, and that was to coincide with the Homes Fit for Human Habitation and the tenant fee ban. And shortly afterwards, there were a further 2 versions of that guide came out with the same date, both in June. One came out in June of last year, and another copy came out in July of last year. And those 2 copies came out because there were some sort of spelling errors and a bit of technical misrepresentation in the May the 31st copy. So the reason I've mentioned it is because If you have a tenancy that started on or after the 31st of May of last year, and you're looking to serve Section 21, please serve all 3 of those versions of the How to Rent Guide before you serve the Section 21, in addition to the gas certificate and the EPC. Because if you don't, then the chances are that when you go to court, if you have to go to court for a possession order, the judge might throw it out and you'll lose your £355. EPCs. As from the 1st of April of this year, if you have a property that has an EPC of less than E rating, you can't rent it. It's as simple as that. So if you have a tenancy which is already underway and you have no plans to renew it, and it is not an E or above rating, you need to address it very, very quickly, because if you don't, there are some serious fines that can be applied. Okay? Now, there are some exemptions, and I actually encourage landlords to consider improving the energy efficiency of their homes, of their rental properties. It increases the asset value of the property, but more importantly, we are, as a society, looking at climate change, looking at the importance of ensuring that our properties are energy efficient and that the tenants that occupy them have affordable opportunities in terms of paying their bills. And the young generation are really focused on this. So, you know, as we move forward, it is going to become more and more of an issue for us. Okay, so there are some exemptions, and I've listed them there. I'm not really going to focus too much on them because that's a bit of a negative, but they do exist. And local licensing schemes can override those exemptions. And if you're particularly minded to do that, you will need to speak to Nottingham or whatever authority you're sort of enforced by to ask them what their opinion is in terms of exempting yourself out of that particular piece of legislation. As I say, not complying with the EPC legislation can result in heavy fines if the period of non-compliance is over 3 months. And as I've already alluded to, as I say, moving forward, this is going to be a big issue for us as landlords. Some other stuff that's happening this year, the capital gains tax rules are changing. I'm not going to focus too much on that because I'm pushed for time. Stamp duty, we're going to be seeing some changes in that in the next budget on the 11th of March. The PM and the Chancellor last summer hinted that they may be raising the minimum threshold on stamp duty from 125 to 500,000. I think that's unlikely, but there was some rumours of that, and that they're looking possibly to cutting the stamp duty rate from 12% to 7%, or possibly moving the levy from the buyer to the seller. And then we're seeing some sort of legislation coming in for agents in terms of money laundering. Tenant fee ban, I'm sure we're all fed up with this. That came out originally on all new tenancies on the 1st of June of last year. It will apply to all tenancies, every single tenancy, as from the 1st of June of this year. Essentially, it means that you can't charge any fee other than a few, including rent. You can charge rent. You can charge security deposits up to 5 weeks. You can charge a 1-week refundable holding deposit. You can charge a reasonable fee for changes of tenancy agreements in terms of changing permitted occupiers, drafting surrender documents, variation of tenancy, changing clauses within tenancy agreements. You can charge reasonable fees for that. You can charge reasonable fees if a tenant has informed you they've lost a key, or you can also charge if the tenant's late paying their rent, as long as and that kicks in, actually is triggered at 14 days. So after 14 days of rent arrears, you can charge 3% above the Bank of England rate. But in terms of everything else, that's all going completely. It's from the 1st of June of this year. You can't charge for credit referencing, inventories, etc., etc. So just bear that in mind. And what we recommend at EMPO is look at your tenancy agreements, make sure there's no clauses within them that mention fees, because that's just going to confuse everyone. And if you've taken more than 5 weeks deposit, don't wait till the 1st of June of this year. Just pay it back now. Just get it over and done with. Just get it dealt with. And it's just one other thing you don't have to worry about. Okay. In terms of fines, again, they're pretty severe. if you breach any of this legislation, and it will also impact if you need to evict under Section 21. Something that was announced a few weeks ago, presently as an HMO landlord, you have to do electrical installation condition certificate, similar to the gas certificate, except that these electrical certificates last for 5 years and not 1 year. This is being extended to all tenancies. So as from the 1st of July 2020, a few months down the road from where we are right now, you're going to have one in place for any new tenancy, and it will apply to all existing tenancies as from the 1st of April of next year. It looks similar to the gas safety in that the copy must be given to the tenants before occupying the property, and they must also have the renewal within 28 days of issue. Civil penalties kick in terms of breaching this legislation, and civil penalties can be up to 30,000 per offence. Now, civil penalties, I'm not going to go into any detail about those because that will demand a separate presentation in itself. But essentially, the penalties for not complying with this particular legislation when it comes out on the 1st of July are going to be quite heavy. Section 21, well, we've heard all about this now. Government have indicated that they're going to get rid of this. We at EMPO are unsure what the timetable is. If you look at the tenant fee ban, they started talking about that in November 2016, and it wasn't brought in until June 2019. Section 21s are connected to all sorts of legislation, housing legislation. All that has to be unpicked in order for them to get rid of it. So, you know what, with Brexit and everything else going on in the background, frankly, I can't see the Section 21 hitting our sector anytime soon. But just beware that it's going to be replaced by a strengthened Section 8. That's what they're talking about. EMPO is part of a committee along with the NLA, RLA, ALA, who have set up a pressure group to try to influence government in terms of where they go with this. But in summary, we're looking for a swift repossessing process, and Section 21 shouldn't be scrapped until a decent court process is in place, and that the grounds are fair to both the tenant and landlord. And we're also looking for a process which is simple and not time-consuming, because at the minute, at EMPO, when we have a landlord who's looking to basically serve possession orders on their tenants through filling in the court paperwork, on average, it's taking 3 to 4 months, which is just ridiculous, particularly if it's for rent arrears. Selective licensing. Okay, we've been talking about that. The government published a review on this in June of last year, and essentially they are looking at possibly setting up a national landlord register to complement selective licensing schemes. And the reason for this is that it will enable councils to easily or more easily locate those rogue landlords who are operating under the radar. Within this review, there were 12 recommendations that it suggested, and some of them were some that clearly professional landlords wouldn't be happy with. For example, where the councils didn't have to go for consultation to renew an existing scheme, and councils could introduce their own conditions linked to their own specific scheme and market area. Sadly, there was nothing in the review for professional landlords and agents in terms of how they should be treated under the selective licensing regime. And we feel as professional landlords that this one-size-fits-all approach is not helpful in developing working together relationships and helping the huge challenges that we all face within housing. Councillor Woodings did mention the Liverpool scheme, 55,000 properties, has been running for 5 years. Well, it will have done as at the 31st of March of this year. When they introduced that scheme, they didn't, as Councillor Woodings alluded to, they didn't have to go to government for permission, as Nottingham had to, and they are, so on renewal, they did have to go back or had to go to government with a report to basically run it for another 5 years, and they were knocked back, and clearly very, very upset. If you read all the reports in the media about the scheme itself, I'm not going to go into the ins and outs of it, but it is the largest scheme in the country, followed by Nottingham, which is the second largest, followed by Newham, which is the third largest. And I personally consider all three schemes to be citywide blanket schemes, where over 90% of a housing area, such as family housing, if it comes under a scheme, in my view, that is a full blanket scheme. And that's all I'm going to say on it. Apart from the fact that Liverpool Council are going to appeal the decision by government, so we're going to be watching that with bated breath in terms of where we go with schemes moving forward. I did say I was going to quickly talk about other matters as well. I think this is important. GDPR, General Data Protection Regulations, came in May 2018. And the Information Commissioner's Office has recently announced that they're commencing a campaign to remind businesses of their legal responsibility to pay the data protection fee, which is linked to the GDPR regulations. Now, we as landlords, sadly, do come under this legislation, and that's simple because we, as landlords, do collect personal data. We store it, we share it for business purposes, and we, as landlords, need to register with the ICO, the Information Commissioner's Office, because we do share our tenants' data with organisations such as councils, deposit schemes, contractors like plumbers and electricians, and failure to register with the ICO, again, can lead to high penalties. But more importantly, if your tenant finds out that you're not ICO registered, they can cause a lot of problems. And I've come across 2 agents in Nottingham where that's happened, where they have been written to by the ICO and they've been asked to fill in loads and loads and loads of forms, taking hours and hours and hours of time. So just bear that in mind. It's £40, but if you set up a direct debit, it's £35. And at EMPO, we provide the privacy notices as well that you can give to tenants, basically explain to them what ICO registration is all about, and that as a professional landlord, you are compliant with that legislation. Now, 8 o'clock is when I'm supposed to finish. I'm 3 minutes past 8. I just thought it would be very rude of me not just to quickly mention about EMPO, for those of you that aren't familiar with our organisation, based in Lenton, Nottingham. We are essentially the largest regional landlord association in the country, 700 members. We've been around since 1942, so we're the oldest regional landlord association in the country. We have a whole bunch of benefits which are listed there. We've just launched a trade catalogue where, as a professional landlord association, we have partnerships with over 50 organisations across the East Midlands that provide products and services to landlords and letting agents. And we've negotiated special discounts, promotions, and incentives for our members. And when you leave tonight, if you haven't collected one of our packs, if you do, you will be delighted to know that one of these very attractive, full-coloured brochures will be in there. Okay, so I mean, as a non-EMPO landlord, I'm sure you can benefit from some of these offers, but I would imagine not too many of them. But anyway, I'm not going to sort of witter on too much about that. But we also do a great lunch event. Every 3 months or so, we attract 70 to 80 landlords at the Crown Plaza, just over the road, for a networking lunch event. We have a great guest speaker coming up on the 6th of March, which is our next lunch event. It's actually Dan Walker, one of the directors of CP Walker. He will be talking about Article 4 in terms of Certificate of Lawfulness for those landlords that are interested. HMO landlords particularly, in terms of what the expectation is when they come to sell their HMOs, what the purchase solicitor might ask for. So I'm sorry it's been really, really rushed, but I'm sort of very conscious of the time. But EMPO membership, it's £60 a year. That's all it is. It's a tax-deductible cost, and we offer loads and loads of benefits, and that's it.